join me for the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This is the Monday, November 9th, 2015 meeting of the Town Council. All members of council are present. The First Selectman is also present this evening. Moving on to the consent calendar, are there any comments to the consent calendar? Any requests to make amendments or changes to the consent calendar? All right, seeing none, I'll pass the consent calendar. Moving on to communications, item A, memo from the First Selectman to Town Council Chairman dated November 5th, 2015 regarding an appointment to the Commission on Aging. B, memo from the First Selectman to Town Council Chairman dated November 5th, 2015, preparing a bid waiver from the Public Works Department for the purchase of a pipe camera system. And C, letter of opinion from Town Attorney John Fracassini to the First Selectman dated November 5th, 2015, regarding proposed revisions and ordinances in the Monroe Health Department. Moving on to public participation, are there any members of the public who wish to participate publicly this evening? All right, seeing none, I'm going to close public participation. Moving on to appointments. A, Vivian Capacetti. Thank you. Ms. Martin.
Thank you, Mr. Chairman. I would ask the council to approve the appointment of Vivian Capacetti, 157 Highland Drive, to the Commission for the Aging for a term ending July 2nd, 2016.
Motion by Ms. Martin, is there a second?
Second.
Second by Ms. Lapellis. Discussion, Ms. Martin?
Mrs. Capacitti's been a resident of Monroe for over 50 years, probably more like over 60 years. She was a former Registrar of Voters, Democratic Registrar of Voters. She served 2 terms on the Town Council. She was the Democratic Selectman candidate, and she is a member of the Senior Center. And this appointment fills a vacancy created by Terry Pontillo.
Okay, thank you, Ms. Martin. Is there any further discussion? Seeing none, all those in favor of this appointment? Any against? Motion carries 9-0. Thank you very much.
Thank you.
Moving on to action items A, Town Council Committee on Finance, Education, Health, and Public Safety Matters. Ms. Hunt?
We have not met, but I did go to the Board of Finance meeting. They did the year transfers, and they approved the credit card payments. I also went to the Board of Education meeting. They had discussion about the turf field, which they will be presenting to the Town Council in the near future in Board of Finance. And that's all the meetings there were. Oh wait, Commission on Aging, they had their meeting. They talked about, with the new strategy, with the capital plans and everything for the town, they had talked about, keeping the senior center where it was, but asking them if Chalk Hill became an option to using their gym for a lot of their programs. They also talked about making policies, because I believe there was some kind of issue over at the senior center that there's no drinking at the park, but the people were tailgating and drinking in the senior parking lot. So they were going to try to put some policy together, because the people going to football games just move over to the next parking lot, which is so they just wanted to start writing some policies on that, because in one place it is allowed and there was nothing in their policy. I don't know if there was any other meetings. Any other boards meet?
No, there weren't. EMS and Board of Health have not met since our last meeting, but I do have a couple of quick things I can comment on. One is, and they're related to the health department. So there's certain ordinances that are on our agenda tonight that certainly have that health is involved in. I want to acknowledge that the chairman from Board of Health, Dennis Connon, is here present tonight. And also wanted to introduce our new Director of Health, Nancy Brawl, who is also here tonight. Thank you. And the other comment I want to make is at the last meeting, Ms. Martin had asked for a report on the status of food service inspections, and I'm happy to report that Ms. Brawl had informed me that I believe it was last Friday, the 5th, that we are 100% current on food service inspections, which is a big feather in your cap. So, thank you. And that's all I have.
And the items, do we know what they?
No,
Commission
no
is-
real
is this
report
coming
for
up?
police commission.
Okay, thank you.
Thank you, Ms. Hine.
Thank you, Mr. Kellogg.
Moving on to action item B, Town Council Committee on Planning and Zoning, Public Works, and Parks and Recreation Matters. That's Mr. O'Rourke.
Yeah, Mr. Chairman, our subcommittee has not met since the last time we met. Parks and Rec's monthly meeting was canceled for this month. Do we have any for P&Z?
We don't.
Inland wetlands? That's all we have for our subcommittee.
It's a fast report, thank you very much. Back to Ms. Hine, I just wanted to note for the council that the turf field committee did ask to get on our agenda for the 23rd, our next meeting, so that will be on our agenda next meeting, just in advance of that meeting. It's nice to get an agenda item a little bit in advance. Thank you about that. All right, moving on to C, Town Council Committee on Legislative and Administrative Matters. Mr. Pelley.
Actually, we met Friday from 4 to about 6 or 6:15, and some of the ordinances that are present on the unfinished business is what we were looking at, adding to them, subtracting, et cetera, to list them. Town of Monroe Section 401A Money Purchase Pension Plan, Post-Employment Benefits Trust, repeal and revisions to Chapter 71, which is the Health District, revision to Chapter 397, which is peddlers and transient sellers, new salon ordinances, and I believe we looked at the Monroe Trumbull Health District resolution, but nothing was done.
Okay, thank you, Mr. Pelley. We have, as you'll see, our agenda has been modified slightly. It's been overdue. We have 2 new committees that we've added to their appropriate spots under action items. So we'll start with E. Let's go back to D. We have the Trumbull Monroe Health District. Mr. Knapp, is there anything to report on that?
I believe town attorney will be covering the majority of that, so I'll leave it up to him.
Thank you very much, Mr. Knapp. Moving on to action item E, Strategic Planning Committee. Mr. Kellogg is the chair of that. Mr. Kellogg?
Thank you, Mr. Chairman. So yes, the Strategic Planning Committee did meet again on November 5th. We took considerable time in reviewing significant number of responses to the 2 memos that had come from the committee on behalf of the council as we discussed at the last meeting. So we spent, I would say, the bulk of the time discussing the Chalk Hill matters. We were fortunate enough to have, I would say, significant valuable input from the superintendent of schools and Mr. Zambri as well. So we had a really good discussion. There's certainly a lot more information that we need to go through and gather. We have in our next meeting plan to discuss zoning issues as it relates to Chalk Hill and identify what those matters might be. As far as the other issues, the list of other significant items that we've asked for, we got several responses. There were some boards and commissions that had not met since, in between those 2 meetings. We certainly want to be respectful of that. I'm going to endeavor, with the committee's help, to reach out to those that we have not heard from and make sure that their voice has been heard, or at least we can affirmatively say they have nothing that they want considered. And as we move forward, I will certainly ask the council liaisons their assistance in making sure we reach out as well. I believe that's it for now, unless Ms. Martin, you'd like to add anything? I certainly welcome that. Okay. Or Frank, since
I would, yeah.
Kevin was there for part of the meeting.
I just want to echo that, I want to say thank you to the superintendent and Mr. Zambri.
Extremely helpful.
It was, at least for me, it wasn't expected that they would even come to the meeting. And certainly Chalk Hill is no longer a building that's under the purview of the Board of Ed, but I do want to just point out to the whole council how willing Mr. Agustin and Mr. Zambri were to continue to assist us and the strategic planning subcommittee with any, giving us any information that we may need. There also was a lot of discussion, we had a lot of questions about the proposed turnover once Sandy Hook, Newtown vacates the school, and what the condition of the building is intended to be, which is what it's likely to be, who is in charge of that. We learned a lot. That's all I can say right now. It's not, you know, we would be here for hours if I regurgitated everything, but we learned a lot about what the intent is, and all of it's very good, but we learned that there are a lot of things that we didn't even foresee, so that we want to make sure it's now on our radar. And I just want to thank him, and he made it abundantly clear that he would, notwithstanding what I just said, be willing to help in any way, shape, or form, being that, and I quote, that he's more familiar with the building and the process than anybody else in town, which is true. So I just wanted to say thank you to him publicly. Ms. Martin?
Yeah, I would just add from that very informative meeting for our first get-together, and you may have mentioned it and I missed it, but one of the avenue that we were discussing taking the next step was to talk to zoning people.
Yes.
And did you mention
Yes, I
that?
did, yep,
Good, thank you.
thank you,
Because I think that's crucial to our tact.
absolutely.
Thank you.
All right, thank you, Mr. Kellogg. Moving on to action item F, the EMS facility work group is also Mr. Kellogg.
Back on, thank you, Mr. Chairman. So the EMS facility work group did not meet last month. However, I do have a short update on the first phase of the needs assessment. It is continuing. The consultant has reported to me via email that the functional aspect of the review is complete at this point. He's now starting to put some square footage estimates to that, which hopefully will be available this week. So hopefully the initial report will be ready for further consideration by the EMS Commission and the EMS Facility Work Group in short order. The second item I'd like to report is that I have been in further contact with the state and now in contact with the Department of Emergency Services and Public Protection in regards to our STEEP grant. We expect a grant contract to be forthcoming. I'm still waiting for the specifics on that, but I want to just report back that the process is underway, and we've had a couple conversations via phone to make sure that process is underway.
Thank you very much. Any questions? All right. Moving on to item G, first selectmen's update, Mr. Babbitt.
Well, the first thing I'd like to do is thank Mr. Ray Knapp for all the hard work he's put on council over the years. You'll be sorely missed. I appreciate the time you've come in over the past few years and discussed things with me. One thing that I'm going to start new is because most council members here in the past have come into my office, but one thing I'm going to do now is actively, and I know Mr. Kapoor has been a good part of this when he was on council in the past, is I want to start having monthly meetings with the Minority Caucus to actually discuss openly your goals and your priorities and your concerns, so we don't always have to hear them up here the first time. We want to be better partners together. One other thing too, and I found this out loud and clear, especially this year, is that there's a lot of unaffiliated voters that want to get involved and do not want to get involved in the political process, whether it be nasty, whether it be nice, whatever. And I'm going to continue to practice my recruiting unaffiliated voters to serve on boards and commissions, and I will gladly put them up before you. We've got to get new people involved. A lot of people have said that they want to get involved, but unfortunately they don't want to get involved in the political process. I'm hoping we can work this out and actually make it a tripartisanship board. And there's a lot of good unaffiliated people. There's a lot of good Republicans, a lot of good Democrats that want to get involved. They just don't want to get through the party system for one reason or another. I urge your help on getting these people involved because there's some bright minds out there that want to get involved in our community.
Okay. Is that all?
That's it.
All right, thank you very much. Moving on to our business for this evening. Item A under unfinished business and item A under new business are both matters that involve our town attorney. So, Mr. Fracassini, if you are not planning on hanging out all evening, I can skip ahead so that you can be free, but first, the unfinished business, item A, is the Town of Monroe Bell Site Discover Insurance matter. As I mentioned to council, Attorney Fracassini has kept me in the loop on this matter and these discussions, and certainly it was also discussed briefly in LMA, but I understand now that we are proceeding with this, so I'll let you tell the council, Attorney Fracassini, anything that you think is appropriate moving forward.
Right. As I'm sure the council is aware, a claim was filed by a developer by the name of Bellsite Development LLC back in 2006. At that time, when we found out later that the insurance carrier for the town at that time was by the name of Discover Insurance Company, and they had denied coverage. We also found that nothing was done to contest that position, and as such, we brought an action against the Discover Insurance, which I had been told at one point had gone out of business, and in reality is a subsidiary of Travelers Insurance Company. When we found out this information, it was just before the statute of limitations, so legal action was thrown together and started. At that same time, we went through the trial process with Bellsite, which led to a decision against the town in the amount of $700,000. Quite frankly, in 45 years of practice, I've seen home jobs in my life, but the way that the town was treated by the court up in Hartford, quite frankly, to me, was reprehensible. We've gone through the appellate court, and we've gone to the Supreme Court, and basically both of those levels of appellate courts have indicated there was no basis whatsoever for the decision as far as the town of Monroe is concerned, and that judgment has been thrown out. But during the process, one of the counts or one of the positions taken by Discover Insurance was that they're not responsible for any contractual liability. And one of the counts that they brought is negligent misrepresentation, which has quasi-contractual and negligence aspects to it. We have talked to the law firm that represented us in the case against Discover Insurance, and they have agreed to do the appeal on a contingency basis rather than charging us on an hourly basis. They gave up a month's worth of fees in September in pleadings that they had filed, and they reduced their normal contingency rate from 33%. I got them to go down to 20%. So basically the appeal, which I think we have a distinct chance of winning, will be brought forth by Attorney Vita's law firm. At that point, what we're seeking is the reimbursement of Mr. Robinson's legal fees, which we're all aware were substantial. We cannot sue or get back the fees that Mr. Dornberg's law firm had, nor that I expended as far as the time is concerned with the trial of the Bellsite case. But we are going after all of Mr. Robinson's fees. And I do think, as I said, that we have a 70% chance of winning this appeal. And I think there's substantial law at this point. We ran into judges in the Superior Court level on summary judgment motions. I think they were wrong. And at this point, I wouldn't have recommended to the town to go forward unless we had gotten the appeal done on a contingency basis. Now, obviously, there'll be money going to Mr. Dornberg's or Mr. Vita's firm if they win, but it's not on an hourly basis, and it is on a contingency basis, which means they only get paid if they win the appeal. I would expect that it's going to take probably upwards of a year, to a year and a half by the time briefing schedules and the matter is scheduled in front of the appellate court. But I would expect sometime in the fall of 2016 to be close to a hearing date.
Okay.
All right?
And the retainer has been signed?
Yes.
Thank you for that. Any
Okay.
questions?
Mr. Smart?
Ballpark, what are Robinson's fees? Do you have any idea?
Pardon?
Robinson's fees?
I'm going to say between $200,000 and $250,000.
Good. Thanks. I'm sorry.
Any further questions, comments? All right. Thank you, Attorney Fracassini, appreciate it. While you're there, I'm going to use my chairman's prerogative and move on to the new business, item A, which is the Monroe-Trumbull Health District. It said resolution. We anticipated potentially a resolution that would come before us. But,
I expected a resolution to have been reached. I can't say, quite frankly, how frustrated I am standing here after what happened today. The town received a letter from the Unemployment Security Division of the state of Connecticut indicating that the town owed the state of Connecticut, whether it be Trumbull or Monroe or both of us, the sum of $6,500 for unemployment compensation claims that were brought by the former director of the health department and the nurse that worked on a full-time basis for the health department. I can tell you quite frankly that the state of Connecticut on more than one occasion, how do I put this politely, misrepresented the legal position of the state as far as this is concerned. I did not get the letter until 4:30 this afternoon, so I am going to talk to this gentleman tomorrow to find out what statutory basis they claim that the towns are responsible for this unemployment compensation liability. Now that is in the amount of $6,500. I have not talked to Attorney Smith, who from Robinson & Co., who represents the district. I was told by Mr. Knapp today that he had tried to call my office. I was in with clients. I never got the phone call. He basically has indicated that TD Bank, quote, has blown up everything. I have no idea what that means. Now, when we started this process back in October of 2014, I had suggested to the selectmen, and the idea was put forth to the town of Trumbull, that they wait a year to work out this situation rather than going forward at that point. So all the problems that we've run into over the last 9 months could have been resolved, and preparations made so we didn't have to go through setting up a health department on a quick basis like we did. They've done yeoman's work in getting off the ground and getting the department running. At the time we started this process, it placed the town in a position, as I advised the town council back in December of last year, that it would leave us with a single district member, or a single district member, only one, that we would have possible exposure to bills, and I could not advise the council or the town of Monroe to go forward as a member of the district, and this council approved dissolving our participation in the district as of December 29th. Over the past 10 months, frustration is being kind in regards to what we were told and what we weren't told. I can tell you quite frankly that it is apparent to me that the board, which I think tried to do its job in the best possible manner, did not follow its own procedures, its own bylaws, that monies were spent that I didn't think were proper exercise of their discretion. At this particular point in time, the three major issues, or the three major debts that we were left with, was a loan that the district took out with TD Bank in order to refinance or restructure the amount of money they owed to the state of Connecticut for the retirement fund. Their bylaws require that they get the approvals of both the first selectmen of Trumbull and Monroe, as well as the executive bodies of both towns. They did not do the latter. I also think that in looking at this, and obviously Mr. Knapp can comment, but I also don't think that they used their funds to use professional consultants for a number of problems that they had. In late March, early April, which is different from the memorandum, and going back and checking my notes, we received documentation from the district that indicated that they had sufficient funds not only to operate to the end of the fiscal year, which was June 30th, they also had sufficient funds to pay off their borrowings. Now, under state law, the district has the right to borrow money to operate. But in that particular statute, which is 19A-243, it specifically states that the municipal members of that district are not liable, underline those words, not liable for those lendings. So as far as the loan for TD Bank is concerned, and the purpose for which it was taken by the district, this town and the town of Trumbull are not liable for those monies. The second debt had to do with a lease that was signed by the district back, I believe, in 2014 for 10 years, without going into whether the lease, and I thought, quite frankly, I thought the lease was commercially viable. I thought it was a decent deal as far as the district was concerned. But at the time of the dissolution, there was still 5 years worth of time left in that lease. I think approximately $230,000 is still owed on it. This town, nor the town of Trumbull, have what they call privity In our business, that means there's no relationship, no interest coming out of a contractual agreement between parties. So that the town never signed anything. The agreement was between the district and the landlord, who, by the way, at that time was still a member of the Trumbull-Monroe Health District. Based on what we found out, they went through the conflict of interest procedure for the town of Trumbull. And basically the transaction was deemed to be a viable one and no conflict of interest was shown. We have gone through negotiations for 7 months now with the landlord's attorney. The landlord's attorney, as far as I'm concerned, improperly locked out the district from getting its personal property. He exposed his own client to what is called a wrongful detainer action under state statute, which basically states that he took property and control of property which doesn't belong to him and he had no right to under the lease agreement. We were told last week that we now have access to that personal property, and I had started procedures on Friday and today to pick up not only the items of personal property that are still due to both towns, and I'll explain why, but also to pick up the 4 vehicles so they would be under the control of both towns. Now understand the TD Bank has what is called the Uniform Commercial Code lien on all of the personal property, including the motor vehicles. So what I wanted was to get control of the property and the vehicles with the understanding that until we got the releases and resolved all the other issues, that we could not use that stuff. And I had set a deadline of a week from this coming Friday to get everything resolved. Today we were told by parties, we got a letter from the state in regards to the Department of Labor. Again, I don't know what happened with TD Bank. I was told by Attorney Smith that the attorneys from TD Bank want to sue everybody. And I wanted to avoid that, but you know, as far as I'm concerned, I don't think they have any basis for any legal action against the towns. Their attitude has been, they said, when are we going to get our money? I said, please provide us with a payoff statement. Because under the note that the district had with TD Bank, the district paid the bank every May 11 or 12 months of payments. It was placed into an escrow, what they call a loan escrow account with TD Bank. And every month they take money out of that account. Well, I've had an argument with their attorneys because I said, you're charging us back interest on what? They said, well, you haven't made payments. I said, wait a minute, you've got $11,000 that covers the time period from May of 2014 or 15 to 2016. What do you mean we haven't? The payment's already been made. In essence, they paid the money up. Then they came back and said, well, by the way, since we sent you 4 letters, we're now going to charge you $2,250 in legal fees. And I said, well, that's coming out of the district's money, it's not coming out of the town's. So I don't know what's happened in terms of what's been blown up. I'll find that out tomorrow when I talk to Attorney Smith. I guess he got a phone call from the bank's attorneys. They want to start a legal action. And I had told the attorney for the bank, I said, I want a payoff statement. Let me know what the figure is, because we had made a proposal, which I will go into with the district, in regards to the payment of that loan. They refused to give me the payoff statement. They said, when are we going to get our money? I said, well, let me know. We're working this issue out. I said, I've already talked to the town finance director in terms of the time. Trumbull's talked to its town finance director. Once we know what the figure is, it's 24 to 48 hours, and we can have checks to the bank. In fact, I said, we'll deliver the checks to the bank, the branches, down in Trumbull Center. Now, the second or third issue was Mrs. Sulick's employment contract. Now, the employment contract was 3 pages long, and in my opinion, a lawyer did not draft this document. It still had another year to run from July 1st of 2015 to June 30th of 2016. All summer, we've been waiting for financial documentation because of expenditures made by the district when they dissolved on June 30th. On that date, all council and parties went down. Personal property was picked up by both towns, and bailment agreements were signed, which are agreements indicating that we could have the use of the property. We told them that if there was an emergency that happened on a community-wide level for either or both of the towns, the emergency equipment we're going to use, bail agreement or not, we could care less. And they understood that. So we went back and forth. We finally got financial statements from the district approximately 5 weeks ago. The offer that I'm going to tell you about was made with the understanding that there were any changes, to either in the financial information or the situations that I discussed tonight, the offer is off the table. Now, the offer that was made to the district was as follows. They would, and by the way, just so you know what they have, based on the records that we received, they had approximately a little under $20,000 in what is referred to as an operating account. The amount of money between the towns of Trumbull and Monroe for their fourth quarter payments to the district was a little over $121,000. So it was a little over $140,000 in terms of funds. The district was told that there was one motor vehicle, a 2007 Chevy Trailblazer, which was used by Mrs. Sulik as part of getting rid of all the claims, getting all the releases, that we would give title to the Trailblazer to her. Out of the operating account, or out of the monies that the town had, we would give the district $7,500. We would reach an agreement with TD Bank in regards to the payoff as far as the monies were concerned for the loan. At that particular point, we would keep the personal property. At one point, they wanted the personal property to sell, or there was consideration of having them sell it in order to meet their obligations, and we would keep all of the motor vehicles. Now, Mr. Condon, who is here tonight, had met with representatives of the town of Trumbull. There had been an agreement on a split of items of personal property. There had been an agreement on a split of the motor vehicles. That happened over 3 months ago. Unfortunately, Mr. Smith, who represents the district, had a family situation which added a little delay to it and which he had absolutely no control over. But we made this offer. We were told last week that the district members who met, I believe, on the 28th of October were happy with the offer and that I expected a resolution within 2 weeks. Now, with what's happened with, I don't know what TD Bank is going to do. I'll find that out tomorrow. And I have no idea about the state of Connecticut. And the state of Connecticut, I won't make any further comments, but what they told 3 attorneys on 3 different days and what they said in this letter is uncalled for, quite frankly. So at this particular point, I still may go forward with picking up the personal items of property that belong to the town and also the motor vehicles, so we have control of those vehicles. But there's probably not going to be anything to report back to you until the end, your next meeting on the 23rd of November. I thought, quite frankly, that I was going to come tonight to tell you that once a few more T's were crossed and a few more I's were dotted, that this was resolved. Now I'm not sure. I really am not sure. I can tell you that no money has been spent by the town of Monroe or the town of Trumbull. The concept of the settlement proposal is that no money over and above what has already been appropriated by the town of Monroe for the fourth quarter of last year's budget would be spent by the town. In fact, hopefully it was going to work out where not only were we going to get the items of personal property and the cars, but we were going to get money. We would keep money out of that amount of money. Now, the finance director has placed that money into a reserve account and taken it out of the line items as far as the budget is concerned, and that's where it's sitting. Any questions?
Questions? Mr. Knapp?
Could I add something?
Absolutely.
As our attorney is, the town attorney has stated, we thought we had everything resolved. My morning started off at 8:15 this morning with a phone call from attorney Brian Smith that things were a go, the vehicles we were going to take possession of. I had talked to the first selectman and the town attorney. We were going to have them all up here, not to be used. TD Bank wanted the titles until their payment was fulfilled. At 1:30 or so, I got a phone call from the town of Monroe attorney, and he basically told me what was going to happen tonight. And again, systems were go. We have all the keys for the vehicles. We have no access to our side of the building. They've already taken one side. At 4:45, I got another phone call from the district's attorney that TD Bank has put a hold on everything. They want the titles before the cars are moved but they had given us 5 days as of last Friday to get them off the property. Now, we can't do anything, as far as I know. That's up to Jack and the district's attorney to talk about tomorrow. I have to get the deeds. They won't even let me drop them off at TD Bank in Trumbull. I haven't found out where I have to get them to. The Board of Directors had agreed in full to the agreement made by both town attorneys and the Board of Directors. We have done everything in our power as Board of Directors to get all the information that was needed by the town attorneys. But again, we were locked out of that area. We had no access to it. And we're not getting any cooperation from the directors in Trumbull. It's Dr. Moyse and myself that have been doing everything. And we're the only two that are employed. I got other things to do than run back and forth to a locked door. That's it.
Understand one thing, just so you know, the setup was down a 2 corporate drive. On the first floor, there are 2 separate units on either side of the hall. The right side, as you walk in from the Monroe Turnpike side, would have administrative positions, nurses. Mrs. Krajewski, who now works for us, was the administrative assistant down there. On the other side of the hall, they had a conference room, Mrs. Sulick's office, and other facilities. There was approximately over 3,000 square feet of rental space, of which 1,200 was not charged by the landlord under the terms of the lease. The landlord rented out the portion of the property where Mrs. Sulick's office was located, and they supposedly had told, I didn't know about any 5-day period because I wasn't told that, but they wanted the personal property to be taken off the property, and they wanted the cars to be removed, which I believe are inside in the garage on that building, which we agreed to do. So as far as delivering the deeds, I will ask you not to deliver anything until I've talked to Attorney Smith and
I'm
Attorney
not doing
Hopkins
anything.
tomorrow. TD Bank can make all the demands they want, but at this particular point in time, I'm not so sure that I'm going to recommend to Dennis or to Brian that you accept those conditions. But I'll wait to
Well,
talk to
they're
your
in my
counsel.
possession, so.
Now, at this particular point in time, understand another thing. The towns have not signed any documents. We've gotten the benefit of no items of personal property. We've signed no what they call third-party beneficiary contracts with any parties that do business with the district. And the towns have gotten no benefit out from the district except for the fact of the, obviously the health services that they provide to the citizens of both towns. I'm comfortable with the legal position on these 3 issues. But this was a way of trying to get rid of this, get the property back, not go above what had already been budgeted by the town a year and a half ago actually, and then keep the personal property, keep all of the motor vehicles, which I thought was a good deal. Is it a settlement that everybody likes? Absolutely not. But at least I thought it was something to get rid of it and not worry about future litigation. I've just got to call the state, and I've got to call Attorney Patrick Fryer, who is one of the attorneys that deals with the attorneys that represent TD Bank. And I checked back on my notes. He's refused 3 of my phone calls, and I don't understand why. I have no idea. I've asked, I called him up, I said, call up, we'll set up, discussing the procedures about getting you paid, how do you want it, do you want a wire, blah, blah, blah. No responses. And I have no idea why. Any questions?
Ms. Martin?
I want to go back to the unemployment claim.
Yep.
You said that came in today?
The unemployment claim came in to the 2 towns today. Last week, we were informed by Attorney Smith that he had received a box of mail from the district members. There were some problems with the district members getting their mail. And one of those letters was a letter directed to the district stating you owed $6,500 for claims made by Mrs. Sulick, and I think Mrs. Henneby, I think, is the nurse. If I'm mispronouncing her name, I apologize.
Yeah,
But at this point, those were the claims. We had gone over this issue back in mid to late spring, contacting the state on between the 3 attorneys at least 5 times. We talked to various department heads there, and we were told point blank that once the district goes out of legal existence, no further claims will be made. Now, at that point, and when I sent you the memo, no claims have been made, as far as I was made aware, because the state never notified us that any claims had been made. Today, when I was here with the Public Works Director and Mrs. Brault to try and find out what items were going to be picked up on Thursday, Kathy Lombardi came in, the Human Resources Director, and handed me a letter that she had just opened in the mail. Now, when I called Attorney Kokina's, trouble is still had not even gotten the letter yet. So he and I are having a discussion tomorrow in regards to that. And as I said, it was too late. Once I tried to call the state, their offices were closed. I'm going to ask what statutory basis, because back in the spring we were told point blank there was no basis and no reason that they would come after the towns. Then once they confirmed that they were aware of the fact that the district did go out of existence as of June 30th.
Is there a date on this, on the unemployment claim? Does it go from?
The only thing that it says, Mrs. Martin, is that there was a balance from a previous statement, and that goes back, it says billing statement, the first one was September 2nd, the second billing statement was October 2nd, the first statement in September has no previous balance, just says current benefit charges are $21.85. The second one indicates that same figure, plus $21.85, an additional benefit payment of $43.70 for a total of $65.76.85.
When you talk about the state saying, that you've talked to the state,
Yeah.
did you talk to the labor division? Is that what you're talking about?
I talked to labor, I talked to unemployment compensation, we talked to the audit department.
Okay, well, when this initially happened, they send a notice out saying that you have a potential, you have a potential liability.
We responded to them.
And you did respond?
Yes, we
Oh,
called them
okay.
up and we asked them what the situation was, okay? And at this point, once the district dissolved, because at the point that dissolved, there were no claims, would there be any exposure or liability on behalf of the towns or the members of the district? They said absolutely not. 3 different attorneys asked that question. All 3 attorneys were given that same answer. They said once the district...
Through the unemployment division of the state?
Yeah.
Okay.
No, we called between the 3 attorneys.
Did you?
Yeah, we talked to the 3 different
When you
divisions.
got the potential liability, did you send a protest? You appealed it? You were going to appeal that decision?
No,
You did not.
but guess what? Never got the notice.
You never got the notice? of
Never got the
liability?
notice. If it was sent to the district, we never saw it. Never saw it.
Because you have, that, there's a
Oh, I
clock running on
understand, I
that.
understand what you're saying. What I'm saying to you is that we never saw anything. I did a memorandum that was submitted to this council 3 weeks ago, and then you notice the memorandum. At that point, I said no, claims, unemployment claims have been made that we had knowledge of. The first time that I had knowledge of this was I got the letter from Attorney Smith on Saturday. He had sent it from his office on Wednesday. I did not see it until today.
And you're going
And
to,
then when I was up here trying to set up arrangements for the Public Works Department, we were given a copy of the letter that was sent to the town of Monroe. That's the first notice I've had from the state of Connecticut on anything except what was, the notice that I had based on what I got from Attorney Smith over the weekend, which I did not see until this morning because it came into my office on Saturday.
so
But
you're
no,
gonna-
I never got anything from the state.
you did.
I'll go back and check my file because I agree with you on the procedure,
Yeah.
but we never got anything.
Yeah, because when I get them,
Oh, I
you have
understand.
like 21 days in which to appeal.
Yeah.
And you can be very successful in that once
We've
you
had,
get in that deadline.
and Ray can contradict me, I would say 1, 2, 3. We've had 4 major meetings with parties from both sides. The last one being about, I say, a month ago. We then made the settlement proposal to them, and at no time did any of those meetings did anything ever come up about unemployment compensation, about the fact that did they receive notice, did they get anything in that regard? Nothing.
Any further questions, comments? So I'm assuming we'll
No, I'll have
More
stuff back,
information.
I will be back here on the 23rd of November.
Thank you very much. All right, moving back to the unfinished business, we have 5 ordinances. We discussed these same ordinances last week. I just want to point out that with our new Chromebooks, I did take the liberty to upload all of the ordinances and Attorney Fracasini's letter to our Google Docs account for Town Council. So if anybody wanted to look at a digital version of these revised ordinances, there's redlined ordinances, and there are the finished version of the ordinances up there as well. So as you see, as all of you are aware, Attorney Fracasini did review, while he's here, he did review the 3 ordinances referred to as items D, E, and F under unfinished business. That's the Health District, Chapter 71, essentially retitling Chapter 71, the revisions to the new salon ordinance, and the revisions to Chapter 397, which is known as the peddlers and transient sellers ordinance. He did not review formally the items B and C, which are the pension, money purchase pension plan, and the OPEB trust. The money purchase pension plan, as you may recall, we received assistance from Attorney John Galliette at Reed and Regia on that. And the OPEB trust, Attorney Marie Fallon at Pullman and Conway for that. Let's move forward with B under unfinished business. Town of Monroe, Section 401A, money purchase pension plan. Before I begin, I want to point out, I just want to thank Attorney Fracasini. His letter was detailed in the ordinance process. I did receive a lot of questions and comments and uncertainty from members of council, individuals in town hall, a lot of individuals just uncertain with the process. It is quite cumbersome. Mr. Kellogg had created a nice flow chart for us that hopefully we can maybe send that to the town attorney to get it blessed, and then we can,
I think there's a couple of tweaks that need to be
right, so
already,
we
but
can get
it's the
that blessed,
first
and it would be a
step.
helpful aid moving forward. We can maybe add that to our rules of procedure, maybe a helpful aid, but as we, but basically the process is that we will discuss these ordinances this evening. All of these ordinances were reviewed on 2 occasions by LNA, and any comments that we may have, proposed revisions, and the sort, we would agree to approve those revisions. I would then call for a public hearing, which I've set up for the 23rd prior to our very lengthy meeting on the 23rd. I'm proposing that those public hearings run 15-minute intervals and start at 6 p.m., run through 7:15 p.m. So I'm cutting into our new council members' inauguration. They're both present this evening, so I apologize for taking 15 minutes of your glory away on while we all get sworn in on the 23rd. But we've been working hard on these ordinances. I want to make sure that they move forward. So Attorney Fracasini, I just want to say thank you for outlining that procedure for us. We don't do ordinances all that often. So essentially, we'll move to public hearing, and if at the public hearing we would consider the comments of the public, and then taking into consideration those comments, we have 2 choices. We can either further revise the ordinances upon discussion of council. If we so choose, we can send it back to LNA for further revision, discussion, and then we'd have to call for another public hearing to determine and discuss the final changes. Otherwise, we can, subsequent to the public hearing, vote to adopt the ordinance, and then goes to the selectman for his approval, his signature or veto, then to the town clerk for publication in the Monroe Courier, and after 30 days subsequent to publication, it is considered adopted. I think I summarized that fairly well. So that's the process. Tonight is called step 2 after LMA has reviewed it. So item B is the Town of Monroe Section 401A money purchase pension plan. We have that as part of our packet. I also printed out, by the way, I printed out and handed out that large packet was courtesy of me making photocopies this evening the ordinances. I want to thank Mr. Bonofsky for being the liaison on this ordinance. As you recall, the last meeting, there was uncertainty as to why we received an opinion from Attorney Phelan that, regarding the OPEB trust, that an ordinance was required, and an opinion from Attorney Galliette that was somewhat silent on that issue. So we did bring through Mr. Bonofsky the differences that were pointed out to us by the opinions of both attorneys to Mr. Galliette's attention, Attorney Galliette's attention, and he did advise us that we proceed with an ordinance. So the ordinance was drafted using, with the intention of keeping the ordinance for the OPEB trust and the money purchase pension plan somewhat similar. So you'll see that they're both extremely alike. It was discussed at 2 LNA meetings. There was some discussion at LNA. Ms. Martin did bring up a number of questions as to the dissimilarities between the two. And essentially what that is the money purchase pension plan references the pension committee that both Ms. Kansky and Ms. Lapellis are members of on this council, while the OPEB trust does not mention or use the pension committee as its quote-unquote board. Ms. Martin did suggest, did have a few questions as to whether it would be prudent to be more efficient and have that pension committee serve on both, and it was determined that it could cause more harm than good, I think, collectively, and it wasn't a recommendation by our attorney. So other than that, we did make a few other changes, giving the council the authority that they have under the charter, so that the council is as the legislative authority, is the one who's actually approving these ordinances and the resolutions that will result if they are adopted, and establishing these plans. So, with that said, if everybody has reviewed the pension plan, certainly open for discussion. If there are any comments, questions, proposed changes. If not, we would call for a public hearing on that. Attorney Francesini, there's no requirement that I obtain a vote or consensus of the council before calling for a public hearing. Is that correct?
It really doesn't specifically state it, but I don't think it probably within your prerogative.
Okay. I don't exercise my prerogative very too often, so I'll probably ask for a consensus vote. Any questions, comments, discussion? All right, seeing none, so all those in favor of me calling for a public hearing? Against? All right, motion carries 9-0. Whether that's a formal vote or a consensus vote, I have the consensus, so I will. She's supposed to be my left hand here. Let's,
Your left hand, I haven't seen, you had a few
I have
minutes
to
ago.
belong somebody.
Oh,
Among
blame
this
me.
organization. All right, so I'm going to call for a public hearing on
November 23rd.
Monday, November 23rd, at the town hall. This will be one of 5 public hearings. It'll be here at Council Chambers located at 7 Faneuil Road, Monroe, Connecticut, to consider the Section 401A Money Purchase Pension Plan Ordinance. The purpose of this hearing is to receive input from the public regarding the proposed ordinance. This meeting will meet the accessibility requirements for the disabled. Anyone requiring special accommodation should contact the First Selectman's office as soon as possible. And the time for this ordinance to be considered to be 7 p.m. Again, Monday, November 23rd, 2015, at 7 p.m. Moving on to,
And that's starting at 6?
well, we're starting at 6. Well, we're starting at 6, but this one is at 7 p.m.
Oh,
on the notice. So
okay.
somebody in the selectman's office was trying to throw me for a curveball. Miss Tanya was trying to.
She's great, isn't she?
I caught that one. All right, moving on. To item C, other post-employment benefits trust, that's the OPEB trust. Again, we It's part of your packet. We discussed this just a minute ago. This is the establishment of a new pension benefits trust. Again, Attorney Mr. Bonofsky is here this evening, so he knows more about this than any of us in this room. So if anybody has any questions, I know you can discuss with us, but if anybody has any questions, feel free to make him work a little bit this evening. Anybody? All right. Any further discussion, comments, changes, anything? All right, so I'm going to ask for a vote to call for a public hearing on this ordinance. All those in favor? Against? All right, that motion carries 9-0. And I'm going to, once again, call for a public hearing to consider this ordinance Monday, November 23rd, 2015, at Town Hall, Council Chambers, 7 Fan Hill Road, Monroe, Connecticut. The time will be 6:45 p.m. and the purpose for this hearing, like the prior, is to receive input from the public regarding the proposed ordinance. The meeting will meet the accessibility requirements for the disabled. Anyone requiring special accommodations should contact the First Selectman's office as soon as possible. Moving on to unfinished business item D. That is the repeal and revisions to Chapter 71, which is currently titled Health District. Again, our packet included reference to this in my packet of documents that I delivered to each of you this evening. Has both the original version and the new revised redline version for your consideration. Again, LNA did review this, and Mr. Kellogg, as our liaison, was instrumental in moving this forward. So, Mr. Kellogg, if you want to just again highlight the changes for us.
Certainly, I'd be glad to. Thank you, Mr. Chairman. So, Chapter 71, as we discussed, currently titled Health District, obviously was enacted at the when the Health District was first formed, and basically outlines the formation, the authority of the district itself, the district's board, and the district's director of health. These changes change the reference from the Health District to the Monroe Health Department, empower our Monroe Board of Health for being the policy body of the Monroe Health Department, and grant the authority to the Monroe Health Director under state statute. I will note that you may have noticed in Attorney Fracassini's review, he did cite one concern from the original language, which was under section 71-4, item C, in terms of the language for removal. To address those concerns after considerable discussion in LNA, we have revised that language to say, by the town council upon the recommendation of the first selectman in accordance with state statutes. Obviously paraphrasing slightly here. So essentially it's a housekeeping change. I think that, any questions? Happy to.
Any questions or comments? Again, LNA reviewed this and we discussed and took into consideration Attorney Fracassini's comments on this, and I think it's important for the full council to know that elsewhere in our charter there are provisions specifically with respect to the selectman's appointment, who has the authority in respect to the selectman's appointment, regarding boards and commissions, which are, those appointments are subject to the vote of town council. So what we did was we mirrored the language from the charter regarding those appointments and adopted it in this section, essentially taking into consideration Attorney Fracassini's suggestion. All right, any further comments or questions? All right, seeing none, all those in favor of calling for a public hearing on this ordinance? All right. So I will call for a public hearing to consider this ordinance on Monday, November 23rd, 2015, at Town Hall, Council Chambers, 7 Fan Hill Road, Monroe, Connecticut. The time will be 6 o'clock p.m. The purpose for this hearing shall be to receive input from the public regarding the proposed ordinance. The meeting shall meet the accessibility requirements for the disabled. Anyone requiring special accommodation should contact the First Selectman's office as soon as possible. Moving on to Unfinished E, unfinished business item E is revisions to the chapter 397 peddlers and transient sellers ordinance. Again, I feel like a broken record, but I did make copies of both the red line and the final proposed versions of this ordinance. And again, Mr. Kellogg was instrumental in moving this forward and brought it before LNA. So, Mr. Kellogg, if you want to highlight us as to the changes here.
Sure. So, thank you, Mr. Chairman. Under Chapter 397, again, it was brought to my attention that current interpretation of Chapter 397 had, in some areas, would place a food truck vendor in a category of either a peddler or transient seller. And within this ordinance, there was a restriction on a peddler or vehicle in being at any one location for more than 10 minutes for any 24-hour period, which essentially does, basically takes that section of potential business out of the town of Monroe. We've heard from constituents who are in favor of the concept. There are many towns that have done this, and they do it very, very well. So the intent is to allow this activity, and the way of doing it is by inserting language under two different sections, where in 397 there are carve-outs of certain activities where the definitions do not apply. And in both those cases, we have added an item, we've enumerated those exceptions first of all, and then we've added item 4, which is to itinerant food vending. Itinerant food vending is currently defined in the Public Health Code. It is regulated by the State Health Code, and those businesses are inspected by local health. So it is consistent with that. So we've allowed it, provided that they are properly licensed by the Director of Health, and they operate with permission from a private property owner, private property, or the first selectman on town property. We're specifically putting those pieces in because the intent is to allow a private business, a private homeowner, or in the case of the town wanting to hold an event, to allow it. We're still not saying that trucks can just go up and down our streets at random. That would still not be allowed according to this. There is some additional language in there that, I don't know if you would like me to suggest that at this time. In the current language, you will also see language in both carve-outs stating not located or operating in a manner that constitutes a public safety hazard. In further discussions with individuals, it's been brought to our attention, and my thought is that that's not necessarily a necessary carve-out, in that an activity that would present a public safety hazard clearly would be in the domain of the public safety agency to enforce that. So having it there is probably not necessary. So I would suggest that we further amend this definition to remove the words under item 4, after the word provided that such a itinerant food vendor is, striking the words not located or operating in a manner that constitutes a public safety hazard, comma, is, so that it removes that, which could be somewhat vague requirement. Given that a public safety hazard would be addressed by police, fire, if such an event occurred, it doesn't need to be in here to be addressed. So, I guess the short message is we want to allow this type of business. They're currently regulated by the health department, and this will allow another area of business to thrive in our community. Other towns have done it, and they've been very successful.
Thank you, Mr. Kellogg. Any comments?
I would like to have a comment.
Mr. Bryant?
I would really like to thank this council for all the good work it's done on redoing some ordinances and getting back to being a legislative body and doing these type of things. Food trucks, as some of you know, I'm a bit of a foodie, not only Mr. Reed. It's not the only foodie on this whole table here, whole dais, but a lot of our restaurants in town do have food trucks, and they couldn't operate here. And it pained me to do that, but within priorities, even though it was a priority to me, the council has been doing its due diligence for the last couple of years. I just want to thank you. This is going to make a lot of our local restaurants happy. They all have food trucks now. They'll be able to actually do them here legally.
Thank you, Mr. Maverick. The other thing I want to bring to the council's attention that we discussed in LA is I did ask the chief of police for his comments. This is certainly an ordinance where the chief of police has mentioned right away in the beginning of the ordinance 397.1. It says no person shall engage in business as a peddler within the town, and it says the same thing for transient seller, unless he shall have a peddler's license of the proper class issued by the chief of police. So this particular provision was within the purview of the chief of police, and I certainly did not want to take any action about his comments. He was kind enough to respond very quickly with a number of very good points, and they were considered. All of his points were considered by LMA, and we did not think that the intent, and correct me if I'm wrong, all three members, and Mr. Kellogg, but the intent of our revisions to this ordinance are simply to exclude food trucks because they're already going to be governed by the health department. And it's contemplated, and there's a state statute, a public health code that does govern these type of vehicles already, which certainly our health department will be governed by, and will follow those. And if this council deems that a further ordinance, when we're doing the food ordinances in the future, as we continue to build the tools that are going to be necessary for the health department to function, if we want to revisit this and add further restrictions to it, it's probably something we will consider in the future, and maybe there is an element of some type of approval that we may consider being required from the chief of police. It was discussed, Mr. Kellogg, someone had mentioned him, some vehicle inspections because they're large vehicles, things of that nature, so we may want to consider it in the future, but as of right now, it's not that we're trying to usurp the authority of the police, but we did feel that if there was a health matter, it would be certainly within the purview of the health department. If there was a safety matter, that's why we have our police, so they certainly would still be free to do what they deem necessary. If there was a traffic issue or some other type of issue that put our citizens at risk, that they would be able to intervene.
And as you said, many of his comments will be addressed through the itinerant food vendor, licensing process through the health department, such as the posting of the license and things like that. So I agree.
Right. I think, we carefully considered written permission. Those are all his ideas that we hadn't even thought of, so.
Correct. Yeah, excellent comments. I want to thank him for getting that back. All right, so we have proposed, I just want to make sure Ms. LaPellis and Ms. Martin are aware that Mr. Kellogg had mentioned a further revision to what we have, which is essentially, and I think it's a good suggestion, it's eliminating under 397 4B sub 4, it will now read, the exclusion will read, or shall not apply to, and I'm paraphrasing, or for to itinerant food vending as defined in the Public Health Code of the State of Connecticut, provided that such itinerant food vendor is properly licensed by the Director of Health and operates with written permission from 1, the property owner while on private property, or 2, the first selectman while on town property. So we are eliminating essentially the following language. We're eliminating he is not located or operated in a manner that constitutes a public safety hazard. And that applies, the same language is eliminated from 397-4B as well as 397-13 sub 4. Is that correct?
397-13, yep, correct.
Yes. Yep.
we had discussed also in LA, it's just coming to my attention now, that 397 for B has a little 1, 2, 3, and 4, because there's a sub B, but 397.13 has no sub letters, and then we just go right into numbers.
I thought that was updated.
I just want to make sure
Sorry.
we're all in agreement with
Say that again?
You're 397.13
Right,
definitions. It goes from 13 to parenthetical 1, 2, 3, and 4.
right.
And the reason why we went to parenthetical 1, 2, 3, and 4, 397.4 is because there's a sub B,
I see, okay.
the little number, letter, number.
So you're suggesting the numbers should be letters?
I think the numbers should be letters technically,
Just to be
however, it matches if we keep it 1, 2, 3. I mean, it's our ordinance, we can do whatever we want. But I don't know if there'll be some grammatical guru out there that's gonna check our work. I'm sure there will be. I'm sure it'll come back on us at some point in the future, but we can do whatever we want. Just wanna make sure we're all in agreement.
It
finding a
was
way.
discussed in LNA to
Yep.
change the,
Right.
Well, we definitely changed the back to numbers, but I think they were originally letters in both. We changed the numbers, but I didn't realize that 13 didn't have a subsection,
Right.
an alpha subsection, so we could have left it as well.
Unless the intention is to make one, because it's the same language, so it reads 1, 2, 3, 4. Not that I want to have a public discussion about this, but
Right.
we are.
but we are doing.
This one to get a sandwich for Christ's sake.
Huh?
Okay.
Any questions?
Can we leave it?
Leave it alone?
Leave it alone?
All right, so with that, with those two amendments, can I have a vote on those in favor of calling for a public hearing as amended? Those for? Against, all right. So motion carries 9-0, so I call for a public hearing on November 23rd to consider this ordinance. Monday, November 23rd, 2015, at the Town Hall, Council Chambers, 7 Phantom Road, Monroe, Connecticut, at 6:15 p.m. The purpose for this hearing is to receive input from the public regarding this proposed ordinance. This meeting shall meet the accessibility requirements for the disabled. Anyone requiring special accommodation should contact the First Selectman's office as soon as possible. Moving on to the last item of unfinished business, which is the new salon ordinance. And again, in our packets and also on our Google Docs account, we have the redlined and final proposed revisions to that new salon ordinance, which is chapter 425. Mr. Keller is also instrumental in bringing this to our attention and seeing this through. So, Mr. Keller, I allow you to continue to educate us.
Thank you, Mr. Chairman. So as we discussed at the last meeting, that we currently do not, as a town of Monroe, have a local salon ordinance. However, the former district had a similar regulation, and salons, which again are in this ordinance broadly defined, they include barbering, hairdressing, cosmetology, tanning, or the services of a nail technician or any combination thereof. They were regulated by the former district, and they still come under some of the regulations of the state of Connecticut. So this ordinance is not imposing anything that these businesses have not been similarly regulated on in the past. So although it is new to Monroe, it is not new to these businesses. Again, as part of the transition process, we recognize that Monroe did not have a local salon ordinance. These businesses are certainly addressed in the public health code, but not to the level of granularity that other items such as food service establishments are. So this ordinance is somewhat, you'll see somewhat technical in nature, particularly in the second part of it. But it basically further elaborates on how the salons will be regulated within the town of Monroe, because these are areas where the state is not sufficiently clear or sufficiently specific. The Board of Health obviously was instrumental in reviewing this, as well as the Director of Health, Nancy Brault, was crucial in putting a lot of this language together. I want to give both the Director and the Board of Health a lot of praise for taking a very balanced approach, in that the intent is to obviously protect the public health, but it is also the intent to do it in a fashion that does not unduly burden businesses or create obstacles that are not necessary, that are not in that spirit of protecting the public health. So there were a lot of things that they looked at and addressed in that regard. So there is, I believe, one somewhat minor change that I'm going to suggest. It may appear that it's just a nit, however, it does have some impacts. Under section 425.15, there's after the word remodeled, there's a word or that is struck before altered that should be there still. We want to say substantially remodeled or altered or converted.
And that would strike the comma.
The comma as well, yes. Yes.
And if I could suggest, in just reading the same section, the last sentence, it reads, any such substantial construction, remodeling, or alteration. We don't define their construction above as substantial, so I would propose just striking substantial from that last sentence, because I think such is referring to the regulated activity above.
Got it. Yep, I agree. So with that said, there's obviously a lot of detail here. I'd be happy to entertain any questions, or certainly could refer them to the health director or the Board of Health chairman if there's something I can't address. I will say that these are consistent with other neighboring towns as well, and in many areas the board looked at what other towns in our area are doing, trying to keep consistent with other localities as well.
And I'll just note for the record, again, LNA reviewed this ordinance on 2 separate occasions and did endorse it to be considered by the full council after a very thorough discussion.
Yes, I did.
So we have 2 proposed alterations to the, I shouldn't use that term because it's in language, 2 proposed amendments to our final proposed ordinance before us, which Mr. Kellogg pointed out. The first sentence, 425.15, first sentence after remodeled, strike the comma and add or. And the last sentence of the same article, 425-15, strike substantial. All right, any further comments? So all those in favor of calling for a public hearing on this amended ordinance? Motion carries 9-0, so I will call for a public hearing to consider this ordinance on Monday, November 23rd, 2015 at Town Hall, Council Chambers, 7 Faneuil Road, Monroe, Connecticut. The time for the salon ordinance will be 6:30. The purpose for this hearing is to receive input from the public regarding the proposed ordinance. This meeting shall meet the accessibility requirements for the disabled. Anyone requiring special accommodation should contact the First Selectman's office as soon as possible. Before we move on, I want to thank Mr. Kellogg for his hard work. I want to thank Mr. Condon and his newly formed, hard-working board, and Ms. Brault for both of you for coming this evening. Thank you for your hard work. I know it's been difficult getting up to speed, and Mr. Kellogg's been informing us, along with other members of your board, that you are diligently working to get up to speed, and we hope to give you whatever tools you need to do a great job. So thank you very much.
Welcome.
So moving on to new business, we took care of item A. Item B is the arbitration award for the town of Monroe and UE Local 222 CILU number 44, case number 2014 MBA 325, and the possible action of the CBS section 7-473 sub C parenthetical D. We spent about an hour before tonight's meeting and a non-meeting to discuss this matter, and I know that my caucus did not have the opportunity to discuss it amongst themselves, so I'm going to call for a recess, a brief recess. It's 9:31, so 15 or so minutes, so at 9:45 we'll reconvene. I want both caucuses to have the opportunity to discuss this, and then we'll come back and have a discussion about this and any action that we may want to take. All right, so call for a recess. Good.
That's yours, this one's mine.
Yes, I'm sorry.
All right, so we're back on the record. So the only item left is under new business, item B, which is the arbitration award, Town of Monroe and the UV Local 222 CILU. As was discussed in our non-meeting, we essentially have two options. We can move to reject the arbitration award, take a vote on that, or we can do nothing, and the inaction of this board would be essentially allowing the award to stand, not be a challenge to the award. So those are our two options. Is there any discussion on this, any comment? Would anybody like to make a motion? All right,
Do you want to talk about it?
just want to make sure everybody has the opportunity, seeing none. Last chance. Again, no action will allow the award to stand.
That's not what you want to do.
Yeah. Yeah, the awards, you're not challenging the award.
That's right.
No action would not be a challenge.
Right.
Correct. All right, so we're moving on. Second, public participation. Are there any members of the public who wish to participate in second public participation? Ms. Hahn.
I'll make it quick. I just want to say it's been a great pleasure. I'm going to be going off council, and there's 2 new members coming on, and it's been a pleasure and an honor working with all of you through these past years. And I'm going to miss it, but good luck.
Well, good
Thank
luck
you.
to you.
Thanking Ray. I was thanking Ray, and I forgot you were going off too.
We're not going in.
No, Ray.
So we go from.
All right, without further, any other members of the public wish to participate? All right, seeing none, motion to adjourn.
So
So moved.
Motion by Mr. Knapp,
Last time, Ray.
second by Ms. LaPels. All those in favor? Motion carries 9-0. Thank you.